Good afternoon. Welcome to everyone who is joining us for charting the course in higher education, adapting to and complying with the new Title IX regulations. We're excited that you're joining us here this afternoon. We're going to give it a minute for everyone to log in. And while we're doing that, just want to go over a little bit of housekeeping. Everyone will be muted when you enter the webinar, so you don't have to worry about that. You can submit any questions that you have in the Q&A box. We will try our best. We have so much material to go through this afternoon, but we will try our best to answer those questions. We may follow up with you afterwards if we don't get a chance to answer all of them. In addition, the webinar is being recorded, so if you signed up for it or a colleague signed up for it and they aren't able to attend because they were pulled into a meeting last minute, they will receive and you will receive a recording of this along with our slide materials and a few other documents such as the unofficial regs as well as the official regs, which we will be supplying to you. All right, at that, just want to introduce myself. My name is Ashling Ehrhardt. I am a partner at Cohen Seglias and the chair of our Title IX group. Our Title IX group is a great group, and we conduct investigations for Title IX. We serve as advisors and decision makers. We conduct trainings. We draft and review policies to ensure compliance. So please reach out to us with any title needs that you may have.
And hi, I'm Sydney Smith Forquer. I'm another attorney working with Ashling, and I also will help with compliance and also further down the road can serve as an advisor or an investigator for your matters that you may have. So with that, we're going to go ahead and jump in. I think the ticker of people added has slowed down to a stable so we can go ahead and get into the contents.
So before
you were going to do, you were going to go ahead.
Yeah, but before we jump in, I just want to acknowledge that all of us are in different places. Some of us may have already read the regulations and the preamble. Some of us have maybe just read the regulations. Some of us may have read nothing and are feeling overwhelmed. So we want you to know that whatever position you're in today, that's okay. We have geared this webinar toward each one of you so that hopefully everyone leaves with some helpful information about the new regs and feeling confident as we move forward towards the August 1st deadline. The new regs are all about flexibility. The Department of Education really embraced the fact that not all colleges and universities are the same. You know, a private 2,000 student college in the Northeast is very different from a flagship university in California, for example, that has 100,000 students. And so with that flexibility, it's nice to have, but there are a lot of decisions to be made because of that. So for the grievance procedures, for example, you're going to have the ability to decide what is best for your college or university. But again, lots of decisions to be made. So this is the time to be meeting with your team. You may decide that you liked the live hearing with cross-examination, and that's what has served you well. The process is already in place. Your school hasn't been sued. You have had no OCR issues, and maybe that's the process that you want to leave in place going forward. You may decide, you know, that was a little bit cumbersome. We had some issues with it. We'd rather go back to the single investigator model that we used before 2020. Also an option. And we'll walk you through all of those options with each different process. You may decide you'd like to do both. So one for sex discrimination, maybe the single investigator model for that, and maybe the sex-based harassment, you still keep the live hearing with the opportunity for cross-examination. So again, lots of decisions to be made, but the overarching theme here is that there is flexibility for your college and university.
Great. So while there's flexibility, you know, what's at stake? What are the implications for your university with these regulations? So just as a very friendly reminder, if your institution receives federal funding, which is pretty much most and all colleges and universities, you do face a loss of federal funding for noncompliance, huge fines, and also it just is a bad look to students, parents, potential students, if there are issues regarding your compliance with federal regulations and Title IX specifically. So there's a lot of interest in the long-term cultural interest in ensuring the safety of all of your students. So we're going to first start with changing definitions. It's right up front in the regulations, so it's going to be right up front in our presentation. And we're going to talk about how some of these terms are defined, how they're defined differently than what they were before, and some also new definitions that weren't previously provided. First, let's look at sex discrimination. So these regulations are trying to provide an educational environment free from discrimination on the basis of sex. So whenever we're looking at what is on the basis of sex, there's a few different categories that the department has outlined for us. Those include sex stereotypes, sex characteristics, pregnancy and related conditions, sexual orientation, and gender identity. Notably, you'll notice sexual orientation and gender identity are outlined as well as pregnancy, and these were not previously broken out in the Title IX regulations, even though there was some debate about whether they were covered anyway. Additionally, you'll notice that pregnancy is going to come up a lot more, and we'll talk about that more later, but that was a category that was not broken out in Title IX regulations. So when we think about what Title IX is really doing, what the procedures and the grievances that you're looking at later, the grievance procedures are doing, previously it was really what we consider sex-based harassment. And now we've got this broader sex discrimination category. And Ashling's going to tell you later about how that can play into the procedures that you have at your university or your college. But first, it's important to understand that sex-based harassment is just a piece of sex discrimination. So sex-based harassment is going to include additional broken out pieces, which include quid pro quo, hostile environment harassment, and specific offenses. Again, these are going to be the closest to what you previously were evaluating under Title IX, but I'm going to go back a slide, and you've got to keep in mind that sex discrimination can happen even outside of that harassment category, and that's still going to be covered by these Title IX regulations. So going into the different categories of sex-based harassment, we have quid pro quo, which is essentially pretty similar to what it previously was defined as, and it's conditioned on a person's participation in unwanted sexual conduct. That unwanted word is outlined in the regs and commented on in the preamble. There was some discussion about whether sexual contact that's conditioned on something is inherently a problem, and the department is just pursuing the unwanted sexual conduct. And the person that could be a respondent for this matter is someone that's authorized to provide an aid, benefit, or service. However, they don't need to be authorized to provide the aid, benefit, or service that is being threatened or used as a piece of coercion as part of the quid pro quo. So think of someone who doesn't have the ability to change grades, but does have the ability to have some kind of authorization within the university, but is using that grade change as a quid pro quo matter. Just because they can't do it doesn't mean that they can't be found responsible for trying. The same way, they don't have to actually act on those threats. As long as the threat is made, then it is still part of quid pro quo. Another piece of the sex-based harassment is hostile environment harassment. This is subjectively and objectively offensive conduct, and it is severe or pervasive. Previously, it was severe and pervasive to reach that standard, and now it is more in line with some other federal regulations by putting the or in there. And that's going to be something that you have to evaluate to determine whether or not the conduct that's being alleged fits that. And this is conduct that limits or denies participation or some benefit from the institution or the university, the education, to a participant or a person that's a student, faculty member in that university. And we'll talk about that definition in a second. So when you're doing this fact-specific inquiry on whether or not a hostile environment harassment has occurred, what are you looking at? Because you're not going to just say, well, do I think this is a hostile environment? There's some actual guidelines, thankfully, for what you are looking at. So you want to see the degree of the effect on the complainant's ability to access the educational program or activity, the type, frequency, and duration of the conduct, the parties' ages, roles within the recipient's education program or activity, their previous interactions, and our favorite category, other relevant factors, and also location of the conduct and the context of the conduct. Additionally, other sex-based harassment that is currently occurring in the educational program or activity. So this is what your the people that are evaluating whether or not hostile environment harassment has occurred, this is what they're going to be looking at. And it is, it's specified that these are the factors. We do still have specific offenses that are outlined outside of that hostile environment. These are going to be sexual assault, dating violence, domestic violence, and stalking. I'm not going to go through the definition for each of these. They are in the regulations, and I do recommend familiarizing yourself with them, but these are going to be in line with what we think of as more criminal activity, where there is already a pretty well-defined definition for the action itself. So when are we evaluating sex-based harassment? Let's talk about some definitions that are going to be relevant whenever you're deciding if this is a Title IX matter that should be moving forward into a grievance process or potentially an informal resolution process. So who can be a complainant? That is a student or an employee or a participant in the program or activity. Student is defined in the regulations as a person who has gained admission. That may be different from your university's typical application of the term student. I know many don't believe someone's a student until they have matriculated, but in the Title IX regulations, it is anyone who has gained admission, even if they are not yet on your campus officially. Additionally, a complaint can be oral or written under the new regulations, and it's a request that can be understood as a request to investigate. So there's no longer this requirement for an incredibly formal, written out complaint that has to be presented to the Title IX office. Now, if someone is speaking with the Title IX coordinator and makes what can be understood as a request to investigate orally, that can be seen as a complaint and should be seen as a complaint under these regulations. A quick reminder, the regulations do go into effect August 1st, 2024. So this applies to conduct occurring from that point forward. Anything that is from July 31st, 2024 and earlier is going to be under the 2020 regulations, and earlier regulations as appropriate if you still are receiving complaints from before those regulations were in effect. I said that the complainant is someone that is a participant, student, or employee in a program or activity. So how are we looking at program or activity? I'm going to talk about the changes mostly here. So previously there were some geographical limitations. So if something happened on your campus, it was Title IX. If it happened off your campus, you could decide whether or not to have a second procedure or process that you were following to kind of pull that into some kind of harassment policy. Now, Title IX applies to any action that occurred on your campus or off your campus, as long as there is some kind of effect that is within the Title IX realm in your program or your activity. So something can occur off campus, but if it's creating a hostile environment between the students or participants on your campus, then it can still be investigated as Title IX. The big key there is that there still is not jurisdiction over events that occur in other countries. So if you have students abroad on a trip or in some kind of study abroad program, there is still no jurisdiction over the active events that occur abroad, but that still may create some kind of hostile environment on your campus upon their return or within your program upon return. So keep that in mind. You still may have something that you need to investigate, but it may just not be the underlying activity or action that occurred abroad. And whether or not you need to be looking to investigate something is going to be looked at as whether or not there's de minimis harm or not. So the way that we're defining that, it's in the preamble. The Department of Education is telling us that is genuine and objectively non-trivial and assessed from the perspective of a reasonable person in an individual's position. Now that is a mouthful, and that is something that is going to have to be evaluated at your university as appropriate. It does say it is it's a harm that is genuine and objectively non-trivial. So that is something that you'll want to keep in mind when assessing whether or not the allegation falls within Title IX and the coverage that we have here. Some additional definitions that we just want to touch on that you will definitely want to read more about as they relate to your university. Confidential employees are important and are discussed quite a bit. That is going to be an employee or recipient whose communications are privileged or confidential either under federal or state law, or because they have been designated as providing services to persons related to sex discrimination, or because they are conducting some kind of human subjects research regarding sex discrimination. It is important to understand that confidentiality is only extended when they're performing the duties that are associated with the sex discrimination. So if you have a faculty member that is serving in some way as a confidential employee, when they're not serving in that role and they're serving in some other role, they're no longer a confidential employee. So that's definitely worth familiarizing yourself with those boundaries. Additionally, we have the term pure retaliation. That's a new term to us. Retaliation is pretty similar in the definition that we have this year versus the previous regs, but it is broken out as pure retaliation, so you may be seeing that more. Pregnancy and related conditions, just want to let you know that that is including pregnancy, childbirth, termination of pregnancy or lactation, and any related medical conditions or recovery that a student, faculty, or participant in your programs may be dealing with. So we'll talk about pregnancy a little bit more later, but that is what that related conditions is referring to. Finally, we have the term for relevant. This is new and is what very hopefully going to be useful whenever we're determining what evidence should be brought in and what evidence should not be brought in to these investigations. And relevant is something that is related to the allegations of sex discrimination under investigation as part of the grievance procedures. Questions are relevant when they seek evidence that may aid in showing whether the alleged sex discrimination occurred, and evidence is relevant when it may aid the decision maker in determining whether the alleged sex discrimination occurred. So we do have a definition to point to now, especially when you have parties that may be pushing to get something brought into the investigation that you've determined as the decision maker is not relevant. We also still have no definition for consent, so you're going to want to look to your university for what they use. Potentially your states may all have their own definitions as well. And with that, Ashling's going to tell you about the grievance procedures now that we know what all of the words mean.
Yes, so formal grievance process is now coined grievance procedures to keep us all on our toes with this new terminology. So if you haven't read the regs yet and you are just kind of overwhelmed by everything you have to do, there are two sections you absolutely have to read, and these involve the grievance procedures. Section 106.4.5, this is the section that deals with grievance procedures for sex discrimination. And then 106.46 deals with the grievance procedures for complaints of sex-based harassment. And again, that has to involve a student complainant or a student respondent at a college or university. So that's what we're dealing with specifically there. I want to also give the analogy. It's kind of confusing to keep all of these kind of new terms and things in our heads. Sex discrimination, if you think of that as like a pizza pie, that's the whole pie. That's what we're now, responsible for complying with under these new regs. The little piece of that pie, just one piece, is the sex-based harassment. And so that covers the topics that Sydney was going over. So that's quid pro quo, hostile environment harassment, and specific offenses. So again, to keep all of these terms within our head, sex discrimination is the big pizza, little slice of the pie is sex-based harassment. So I'm going to first focus on the grievance procedures for sex discrimination, again, for the whole pizza pie. It applies to sex discrimination that is not sex-based harassment, again, so that little exclusionary piece of the pie is not covered here. And it's employee on employee sex discrimination too. So there are basic requirements, and a lot of these are the same that were under the 2020 regs. So you have to treat parties equitably. The Title IX investigator, and the Title IX coordinator, the investigator, and the decision makers, none of them can have a conflict of interest or any bias. And that makes sense too, right? I will point out decision maker is spelled like this in the new regs for people who are wondering if we misspelled it. There's no dash in between decision maker anymore. It's all one word, and we've created a new word here that's not present in Merriam-Webster. And the decision maker can be the same person as the Title IX coordinator or investigator. So we are going back to, we can do single investigator models. That is permitted under these regs. Again, it's going to be a decision for your college or university what you like to do. There has to be a presumption that the respondent is not responsible. Establishing reasonably prompt timeframes for major stages. So let's work through that a little bit. The major stages have been spelled out for us. It's evaluation, investigation, determination, and appeal. So those are the 4 major stages. You can add more stages if you have more at your college or university, or that makes sense to you. And you get to decide what these reasonably prompt timeframes are. So we're not kind of beholden to the 60-day time frame that we were before. And, you know, again, as long as it's reasonable, as long as it's still prompt. I know as an investigator under the 60-day time frame, sometimes I would get an investigation and 2 weeks have already gone by, under that initial evaluation stage before we're actually conducting the initial interviews. And so now it's nice. All right, maybe you can say, all right, well, the initial evaluation stage is going to take 7 days or 10 days. The investigation stage, maybe, based upon our history, maybe we were able to complete those in 30 days. God bless you if you were able to. Maybe 60 days was something that worked for you for the actual investigation. Again, here's the flexibility that we see. What works best for your school. And as long as you can explain that and that it is considered to be reasonably prompt, all things considered, then that's going to be, something that you can do. The determination stage, that's another one. How long does that typically take? What about your appeal process? Think about how long that lasts. How many days do the parties have to file the appeal? Once it's filed, how long does the decision maker on the appeal get to make that decision? And so again, these are all things that you get to put the dates on and the timeframes on, which again, I think is nice to have that flexibility. You're also allowed to give reasonable extensions. That's okay with good notice, with good cause and notice to the parties. Also, there's a concern about taking steps to protect the privacy of the parties and witnesses, and we'll talk that through a little bit more. So it's kind of a balancing act. So on one hand, you have to protect the privacy of the parties and the witnesses, but on the other hand, you have to also make sure that they are able to obtain and present evidence, including by speaking to witnesses. They have to be able to consult with their family members, confidential resources or advisors. So again, it's kind of this balancing act as to providing privacy, but also allowing the parties to be able to, gather up their evidence and speak with whom they need to speak to prepare for the actual investigation. There has to be an objective evaluation of all of the relevant evidence as well. We're going to move to the next slide and talk about excluding certain types of evidence, and this is familiar too under the current regs. We're going to exclude any evidence, even if it is relevant, if it's protected by a privilege under federal or state law, if the evidence was provided to a confidential employee. So that's where you see, as a university, it's an important decision who you want your confidential employees to be. Who are you going to name as those confidential employees? If students go to them, they want the assurance, the student wants the assurance that that's not going to be reported to the Title IX coordinator. And again, that would remain the case unless the student later decided to waive that. Any records of physician, psychologist, other recognized professional, paraprofessional, again, unless that's waived. Some students do like to waive that when they get to the hearing because they want those records to be a part of it. Evidence regarding a complainant's sexual interests or prior sexual conduct, unless it's offered to prove that someone other than the respondent committed the alleged conduct, or it's offered to prove consent. So again, we see the similar language there that we have under the 2020 regs. So step one, when you get a complaint comes in, it's either written or oral. Your first decision is it's under this evaluation umbrella. What are you going to do with this complaint? Are you going to dismiss it or are you going to investigate it? Dismissal of the complaint, it's discretionary for several reasons. One of them, you're unable to identify the respondent, makes sense. The respondent is not participating in the education program or activity and is not an employee. That's another reason why you may dismiss the complaint. The complainant voluntarily withdraws any or all of the allegations. So again, we have a little bit more complainant autonomy under these regs, where the department really wanted to give that autonomy to the complainants to decide whether to move forward or not. There's also a process in place, which we will talk to a little bit later, about Title IX coordinators and when they can initiate a complaint. It's very, very spelled out for Title IX coordinators about what they have to consider before they do that. So here, when we're talking about a dismissal of a complaint, so either the complainant has voluntarily withdrawn any or all of the allegations, the Title IX coordinator has decided, has declined to initiate the complaint, and the remaining conduct does not constitute sex discrimination. So in a situation like that, that is certainly a reason why a college or university could dismiss the complaint. Finally, if the conduct alleged doesn't equate to or doesn't constitute sex discrimination, that's again going to be another reason for allowing a school to dismiss. If you are dismissing for that reason, though, please note that the school has to make reasonable efforts to clarify the allegations with the complainant. So if there's anything unclear there, that college and university has to first go back to the complainant, really to make reasonable efforts to understand what the allegations are before dismissing. The school has to provide notice of the parties of the dismissal. So if the complainant has been notified, but the respondent has not yet been notified, you don't have to, obviously notify the respondent because he or she is not yet aware of the actual complaint. So the appeal process, there has to be an appeal process in place to challenge the dismissal. And again, when you're thinking about your time frames, this is all part of that evaluation stage, allowing for that appeal process to challenge dismissal of any complaint. If it is dismissed, you have to offer supportive measures to the complainant and the respondent if the respondent has been on notice. So again, this is another thing that the Title IX coordinator is going to put on his or her hat and have to do going forward. Next, the step 2 is, so if you do decide you're not going to dismiss, you're going to investigate this complaint, same thing, notice of allegations. That's going to include, a lot of the similar things, the applicable grievance procedures. There has to be sufficient information to respond. So you have to know the identity of the parties. You have to know the conduct alleged. You have to know the date and location of the alleged conduct. All of that has to be contained within that notice of allegation to the extent that you know it. A statement that retaliation is prohibited, that also has to be within that notice of allegations. Another statement that the parties are entitled to equal access to relevant evidence or an accurate description of the evidence. We're going to talk about this a little bit further. So the school has an option to either provide a description of the evidence. And if the school does provide a description of the evidence, the parties have to be entitled to request access to the relevant evidence if you're not going to provide it outright. You'll notice here, so again, we're dealing with section 106.45. This is sex discrimination grievance procedures. There is no mention of an investigative report. That does not mean you can't still do one. So these are just the bare requirements of what you are, you have to do to be in compliance. If you say, listen, we have investigative reports, we like how that works, we like that we can document this a little bit better, we just feel like that really works for our college and university, keep them. Again, you can always do more, but you can't do less. This This is the bare bones of what you're required to do, what I'm talking to you about through this grievance process. Keep in mind too, similar to the current regs, if there's any change in the allegations, you have to provide that updated notice of allegations to the parties. Consolidation of complaints. This is spelled out too. Just want to hit that a little bit because we do have these two different, grievance processes. We have 106.45 and then we have 106.46. So let's say you're trying to consolidate a sex-based harassment claim under 106.46 and a sex discrimination claim again on the other section, so 106.45. If you do that, you must use the higher due process standard. So if you do that, if you're consolidating claims from both of these grievance procedures, you must use all of the requirements set forth in 106.45 and 106.46. So when are some of the opportunities that you can consolidate when there's, allegations against more than one respondent? When there's allegations by more than one complainant against one or more respondents, and it's one party against another party. So again, these are the things you need to consider, but if you have different procedures and that's how you're going to move forward under these two different grievance procedures, you need to ensure that you're giving the due process rights allowed if you're consolidating under both. For the schools must, and this is true now, the burden is on the school, right? It's not on the parties to show that they're, that they've met a certain standard. It's on the school. The school has the burden to investigate these and to show that it's been reached. The relevant standard has been reached. There has to be an equal opportunity to present facts and evidence and equal access to both parties. That's a key theme throughout all of this, that equal access, equal opportunity for both parties. How do you do that? There's access to relevant evidence, or there's access to an accurate description of that relevant evidence. So if you're providing a description, again, you have to provide relevant evidence upon request of any party. So to me, best practices to me is just provide it. But again, that can be something that your school can decide on its own. There also has to be a reasonable opportunity to respond to the evidence or to respond to the accurate description of the evidence. You have to take reasonable steps to prevent and address the party's unauthorized disclosure of the information and evidence that's obtained solely through these grievance procedures. So that's another, again, we're trying to protect the privacy of the parties throughout. Questioning the parties and the witnesses, during this investigation stage, there has to be a process in place that enables the decision maker to question the parties and witnesses to assess credibility. Credibility is not defined in the regs. It's something that hopefully the decision makers that you're using are familiar with. If not, they should be trained upon how do you assess credibility. Again, you're only assessing credibility when credibility is in dispute and it's relevant to the allegations. So for sex-based harassment, I know we're not talking about that right now, but I can't imagine a situation where credibility isn't in dispute. Sex discrimination, we're going to see, more about what these facts are going to look like. So if it's not in dispute, then you don't need to assess credibility, but otherwise your decision maker has to make those determinations and be able to assess credibility. Once we get to step 3, the determination, very similar. You have to notify the parties in writing. You need to include the rationale and you need to include how to appeal that decision. Again, we're using the preponderance of the evidence standard. Unless your school uses clear and convincing in all other comparable proceedings, which I've never seen under the 2020 regs. Every school I dealt with was using the preponderance of the evidence standard. So likely that's going to remain the same for most schools. For the appeal process, you have to offer the parties the appeal process that at a minimum is the same that's offered in comparable proceedings. So if you don't offer an appeal process in comparable proceedings, you don't have to offer an appeal process here. Again, we're under grievance procedures, sex discrimination. We're going to talk more about sex-based harassment, which is different. You must offer an appeal there. But for this, if you don't offer it in other comparable proceedings, you do not have to offer it here. But if you offer it in any other comparable proceedings, you must also offer it here. That's your minimum requirement. Okay, sex-based harassment. So this involves student complainants or a student respondent, and it's at post-secondary institutions, so at your higher ed institutions of colleges and universities. If you're under sex-based harassment, you must apply everything I just told you about the grievance procedures for sex discrimination also apply here. So you're combining 106.45 along with 106.46. So that's an important consideration to make while you're going through this process. So again, everything I just told you is all true here, and then I'll give you the additional requirements for sex-based harassment. So step one is the same. You're going to evaluate it. The complaint comes in, written or oral. You're going to decide whether you're going to investigate or dismiss. If you dismiss the complaint, you must provide written notice and the basis for the dismissal simultaneously to the parties. And again, if the respondent has not yet been notified of the allegations, you do not need to provide that to the respondent, only to the complainant. Here's an interesting one. Although the complaint does not have to be in writing, it can be oral. If a complainant is withdrawing the complaint, you must get the complainant's withdrawal in writing. All right. So complaint itself doesn't have to be in writing, but if the complainant is withdrawing the complaint, must get that in writing. And again, that can be an email. It doesn't have to be any type of formal form that you have, but again, must be in writing. Step two, we're going to investigate the complaint. So again, notice of allegations. There have to be sufficient time to prepare for the initial review. The new regs do call out if there are reasonable safety concerns for the safety of any person, not just the complainant. The school can delay providing that notice of allegations. But again, that cannot be based on speculation or stereotypes. There has to be an individualized safety and risk analysis done before you can go down that route. The notice of allegations must include, again, presumption that the respondent is not responsible. The parties will have the opportunity to present relevant evidence to a trained, impartial decision maker, that they can have an advisor of their choice, which can be an attorney, and that the statement must also include that the parties are entitled to equal access, to the evidence and or to the report. So here we see, again, we've got the relevant evidence or the investigative report that summarizes the evidence. So here an investigative report is called out, but again, it's actually not required even under sex-based harassment. So that's a big change. You can just provide the parties with relevant evidence. And if you do provide an investigative report similar to what you're doing now, you also have to provide access to the relevant evidence upon which that written report is based. All right, so under the complaint, again, we're sex-based harassment. We're still in the investigation stage. The schools must provide written notice to the parties, very similar: date, time, location, participants, purpose of all meetings. I think that's important, and with sufficient time to prepare. You have to provide parties with the same opportunities to be accompanied to any meeting by an advisor of their choice. The schools can make restrictions, to the extent that they, an advisor can participate, but as long as those restrictions, again, apply equally to the parties. We're going to see that language time and time again. Support persons, again, deferred to the college or university to decide, as long as the same opportunities are provided to both. So you could have an advisor, you could also allow a support person, again, as long as it's a fair process for both parties. Expert witnesses, schools have discretion, again, as long as it applies equally to both parties. You have to allow for a reasonable extension of time for good cause with written notice to the parties for any reason, that would cause that delay. So again, very similar to the current regs and similar to what most of you are doing already. So under the complaint, you have to access you need to have access to either the relevant evidence or a written investigation report that summarizes the evidence. And we talked about this already. We need to give access. If you're giving an investigative report, you need to provide access upon request to the relevant evidence upon which it is based. So here we get into the good stuff, live hearing versus no live hearing. We do have the option, you can decide what works best for you. If you like the live hearing, if you don't like the live hearing and you can't wait to be done with it. We're going to, you have to make sure that the parties are given a reasonable opportunity to review and respond to evidence. So if there is a live hearing, then the review must be done before the live hearing. If there is no live hearing, it's discretionary as to when that response can be. So it can be prior to a hearing, it can be during a hearing, or both. So it really, again, you have to decide what works for you and what's best for you. A lot of you have already lived through this before 2020, right? Where you didn't have live hearings and you were doing single investigator models. That can be brought back if that's something that you want to see at your college and university. As in terms of privacy, you have to take reasonable steps to prevent disclosure of the parties and their advisors of unauthorized information that they obtain through this grievance procedure. So that's another interesting twist. What's that going to look like for you? Because, your advisors could be, employees of your school. They could be people completely not related over whom you have no jurisdiction. So that's going to be an interesting thing to implement, I would say. All right, when we're questioning parties and witnesses, again, under the sex-based harassment grievance procedures, there has to be a process in place for the decision maker to assess credibility. Again, credibility has to be relevant to the allegations, and it has to be in dispute. And again, for a sex-based harassment claim, I don't know when that would not be the case. So credibility is certainly something that your decision maker is going to have to decide. If you decide not to have a live hearing, this is how this is going to work. There is going to be questioning. You have to allow the investigator or the decision maker to ask questions during individual meetings with the party or with witnesses. Then you're going to allow each party to propose questions that the party wants to ask of each party or witnesses. The investigator or decision maker will ask those questions during individual meetings, including follow-up meetings with the parties and witnesses. You have to provide each party with an audio or an audiovisual recording or a transcript of these meetings with the investigator or decision maker with enough time to allow that party to propose follow-up questions. So again, you're not having a live hearing, but your investigator, your decision maker is going to have to be recording every single meeting with the parties, with the witnesses. Those have to be provided, to the other parties, and they need to be able to be able to listen to them or review the transcript, and then to be able to propose their own follow-up questions after that. So that is if you decide no live hearing. If you go with the live hearing, it's going to typically, be what we have now. There's no term called cross-examination anymore. But the language is questioning. So the questioning can be done either by an advisor, which is what we have now, right? Or by the decision maker. So the parties can submit questions to the decision maker, and the decision maker can be the one to ask these questions of the other party. Similar to now, at no point may a party ask questions of another party. So even if we get to the live hearing and your school decides that it wants to do live hearings still, you can certainly allow that, But again, all of the questioning of another party needs to be done by the advisor or by the decision maker. If the school allows an advisor to conduct questioning and the party does not have an advisor, similar to now, the school has to provide a party with an advisor of the school's choice at no charge. The only caveats to that are it cannot be a confidential employee, and it can be an attorney advisor, but it's not required to be an attorney. With questioning the parties and witnesses under the sex-based harassment grievance procedures, we're going to see that the decision maker determines if a question is relevant. So again, this is similar to what we have now. You have to explain, the decision maker must explain any decision to exclude a certain question. If the question is relevant, the question must be asked unless it's clear or harassing. There is an opportunity to clarify and revise a question to allow the party to re-ask it in a different way. And then schools can adopt any other sorts of rules regarding decorum, regarding the questioning of parties and witnesses, again, as long as it's applied equally to both parties. We have the, when there's a refusal to respond to questions, there's this talk about inference, can a decision maker draw an inference, about what that means. So a decision maker, when a party is asked a question and the party declines to answer it, the decision maker can choose to place less weight or no weight on the statements of that by that party or witness who refused to respond to that question. So again, less weight or no weight. The decision maker cannot draw an inference about whether the harassment occurred based solely upon that refusal to respond. So that's an important distinction there. On the live hearing procedures, again, these are optional. They can be in person, they can be in separate locations, similar to now, with the ability to see and hear the other party or witness, while that person is speaking. You must create an audio or an audio-visual recording or transcript and make that available to the parties for their inspection and review. All right, the termination, again, we're under sex-based harassment. All of the steps that we went through for the 106.45 also apply here. And in addition to the written determination has to describe the alleged harassment. It has to set forth the policies and the procedures that the school used to evaluate, those allegations. The decision maker's evaluation of relevant evidence and determination whether harassment occurred. And then we're going to talk about, disciplinary sanctions, other remedies provided to the complainant and other students who experience the effects of the harassment. And then it needs to set forth the appeal procedures. Unlike the sex discrimination, you must provide an appeals process under the sex-based harassment grievance procedures. It's going to be the same process for appeal of a determination and as well as a dismissal of a complaint. So it's going to be the same process that's going to be in place. 3 bases for appeal: procedural irregularity, new evidence, conflict of interest. These are the same that we've seen. You can add additional bases for appeal, again, as long as they are equally available to all of the parties. Title IX coordinators, you have your hands full. Your plates are big and they just got expanded. There has to be one Title IX coordinator who's, the big boss, who's the person in charge. Some schools have a Title IX coordinator for employees and another one for students. Now there has to be, one Title IX coordinator who's in charge, who's responsible for coordinating that school's compliance. I touched a little bit earlier, just briefly, upon the requirements for when a Title IX coordinator can initiate a complaint. It's a very specific 8-step determination. So these are all of the factors that the Title IX coordinator must go through when it decides to file a complaint. And the coordinator, the very first step is the complainant's request not to proceed, and that's a big one. I've seen that play out in a lot of different schools where the complainant does not want to proceed and the Title IX coordinator proceeds anyway. So again, that's something that you have to determine before you file the complaint. Safety concerns, risk of additional sex discrimination, the severity of the allegations, the age and relationship of the parties has to come into play. The scope of the allegations, the availability of evidence, and the school's ability to address those allegations. Those are everything that the Title IX coordinator has to consider. In addition, after evaluating those 8 steps, that's not enough. The Title IX coordinator has to then determine whether the conduct presents an imminent or serious threat to the health and safety of the complainant or another person, or the conduct as alleged prevents the school from ensuring equal access to an education program or activity. So again, you're evaluating those 8 steps, then you're seeing, is there an imminent or serious threat? Is there conduct that prevents the school from ensuring equal access? If the answer to all of those questions, are yes, then the Title IX coordinator may initiate a complaint. So a lot of steps here are involved, but it's nice to have it set forth so clearly that the Title IX coordinator, knows what it must consider before it can't just sign a complaint. It really needs to take a step back and to consider all of these things. Again, the Title IX coordinator's hat, it's huge. It's getting bigger. Especially with equal access and preventing discrimination for pregnant students. That's going to be, I think, another big responsibility for Title IX coordinators going forward. If employees, so under the new regs, employees must provide known pregnant students with the Title IX coordinator's contact information and inform the student that the Title IX coordinator can coordinate specific actions and support. Some of these reasonable modifications that a Title IX coordinator can do, the ability to express milk, breastfeed, eat, drink, use the restroom, absences to attend medical appointments, access to online or homebound education, changes in schedule or coursework, a larger desk, a footrest, elevator access, rescheduling tests and exams. Like, these are some of the things that the Title IX coordinators are going to be, responsible for helping a pregnant student going forward.
Okay, so now we're going to talk about the mandatory training that all of you have probably started to think about since we're getting close to that August 1st date. So when are you required to give training to the members of your university and college? Well, upon hiring or change in position that would affect their role within the Title IX world, and additionally annually. So right now, it's not incredibly clear, but our best practice is that you should be trying to endeavor to get everyone trained by that August 1st deadline. There has not, as far as I'm aware, been a mandate of that is a deadline for every employee, because there is this annual training requirement that is a little bit more up for interpretation, but this is what the minimum is upon hiring, change of position, or annually for everyone. And all employees have to be trained. So there are different tiers of training, though. Don't worry, you're not doing the same training for your Title IX coordinator that you are for a random staff member that works in the registrar's office. Every employee must be trained on the school's obligations under Title IX generally, the scope of the conduct that could institute a Title IX violation, and the notification requirements. So that's what everyone has to receive. And then there's additional training that has to occur for your investigators, your decision makers, and your other people within the Title IX sphere that are responsible for grievance or supportive measures if those people are not a coordinator or an investigator or a decision maker. Those people have to receive additional training related to their specific responsibility, but also regarding the grievance procedures, impartiality, and the term relevant. So we talked about that definition earlier. That definition has to be explicitly part of their training, which is really interesting that they're carving that out. Additional training, and I should say those categories of people I just mentioned have to also receive that all employee training, of course. There also are specifics for informal resolution facilitators, but as you can guess, they need to be trained in the informal process and also impartiality. Notably, they don't need to be trained in the grievance procedures or the term relevant because they're not going to be evaluating evidence or conducting those grievance procedures. So if you have someone doing informal resolution that does not at any point serve one of these other roles, then they don't need to be trained on those other things. And that's for you to determine based on the size of your staff and the size of people that you have working within your Title IX sphere at your school. Finally, Title IX coordinator and designees, as you can imagine, they have to receive all of the above training, as well as additional training related to their specific duties, record keeping, and the training requirements. And that training, I should also say, it can be internal, it can be external. You can hire someone, you can have your Title IX coordinator perform the training for everyone except for themselves. So there's a lot of flexibility depending on the size of your school, what you've done in the past, what your expenditures are, for you to determine what the best course of action is for your group. There's also some really specific requirements for record keeping. You must keep records for at least a period of 7 years. That is the minimum. You can, of course, keep them longer, especially with the digitization now of records. It's a lot easier to not keep these giant boxes of paperwork. So you may look to your university for what their general data and records requirements are. But of course, remember, the minimum is 7 years, even if your university for other matters does not keep records for that long. The records that have to be kept fall into 3 different categories. Either the informal resolution process or grievance procedures that were used for each complaint, as well as the outcome of that complaint, is one grouping of things that you must keep. You must also keep each notification of conduct that reasonably may constitute sex discrimination and the actions taken. So let's say that there is a notification that comes into the Title IX office that is not reasonably believed to be a complaint or a request to investigate, but still could be some kind of notification of conduct. That still needs to be recorded in your records, and any actions that the school takes needs to additionally be recorded. That could also mean someone comes to your office and asks for supportive measures and explicitly says, "I do not want this to be investigated." That is not a complaint, but that still may be a notification of conduct, as well as actions taken, meaning supportive measures that you've put in place. That all needs to be recorded and needs to be held onto for at least 7 years. Finally, your training materials, whether it's internal, external, however you want to handle your training, what you use to train your people must be kept. And that's really good for your school as well, because what if there's some kind of question down the line about what kind of training was implemented, what your staff were told to do, you can point to what was actually given to them and shown to them. So it's a good thing to keep in mind, that it helps you and your office protect itself as well if there are questions later. Okay, let's talk about informal resolution. We've talked about the grievance procedures and everything that can occur under there for the 2 different categories of allegations, but let's talk about informal resolution and how it differs from the informal resolution requirements that we have currently. So informal resolution can be offered or can be used at any point prior to a determination in the grievance procedures. It must be after a notice of allegations, but keep in mind that this can be a fairly fast process. So if someone comes to your office and tells you the things that they're complaining about, that is oftentimes enough to put them on notice. It's an oral complaint. You now know what the allegations being alleged are, and you just need to make sure that both parties, prior to the beginning of informal resolution, have been notified of what those allegations are. So you don't have a respondent who says, "Well, you're asking me to do informal resolution, but I have no idea what you're accusing me of." That's all it is. There's not anything past that has to be provided. Additionally, the Title IX coordinator now has a lot more discretion to determine whether or not informal resolution is appropriate. That goes both ways. There used to be a requirement that all Title IX matters involving 2 students be allowed to do informal resolution if the students ask for it, if both parties ask for it. There's no longer that requirement, so the Title IX coordinator has more discretion there. Similarly, there used to be a requirement that any complaint regarding a faculty member or staff member and a student was not allowed to have informal resolution, and that's no longer the case. In your elementary and secondary students, that is still the case, but in a university or collegiate situation in a higher ed environment, if the Title IX coordinator decides that informal resolution is appropriate for a party that is a student and a party that is a faculty or staff member, that can move forward, but with the discretion of the Title IX coordinator. Ashling, I don't know if we want to make a comment about the fact that we've reached 1 p.m. and we do still have a little bit more to finish up. We're going to push through, but we of course, thank you for taking the time to listen to us, and the fact that we have a bit more material than I think anyone was anticipating would fit within an hour. But you're welcome to stay. We're gonna finish up if that's okay with everyone that is staying. So, continuing with informal resolution, your facilitator can't be an investigator or a decision maker in that particular matter. You can have someone trained as an investigator that serves in other matters, or trained as a decision maker that serves in other matters. They just can't be the decision maker or the investigator for that matter. That will come into play more for your smaller schools that may use a model right now where they have one person acting as the investigator and the informal resolution facilitator. That can't happen anymore under these new regulations. So just look at what you need to do to structure your office. Additionally, the informal resolution facilitator has the responsibility to take steps to ensure that sex discrimination does not continue or recur. So with that, make sure that the things that are being agreed to are actually solutions that are preventing future violations on your campus by these parties or in this involved with these allegations. If the informal resolution doesn't actually address those matters, then you may need to step in and ensure that they do. We also have a lot of supportive measures, as you've heard throughout our presentation. Those are discussed a lot, whether to give them, whether to not. One thing that you will see is that supportive measures must be offered and coordinated by the university. That's the recipient of federal funding. And they must be offered timely, and must be offered with a timely opportunity for them to be reviewed. So let's say a party asks for something and you decide that a appropriate supportive measure is slightly different. They also must have a timely opportunity to review that determination and then request, and we'll talk about this in a second, request for modification. You must not offer supportive measures that unreasonably burden either party or are punitive or disciplinary. This is the same as before. This will feel very familiar if you were someone that evaluated for supportive measures at your university or college. And you must not share the details of supportive measures with others, including with the other party in a matter, unless it's required for implementation. So you can't, advertise that someone's receiving supportive measures, and you'll want to talk to them about what is appropriate for implementation if there does need to be some kind of ask made of a faculty member or someone else in the university that touches on what that measure is. And then supportive measures may be terminated or continued following informal resolution. Typically, that's part of the agreement and will be decided upon within that process, but that's something just to keep in mind. Another requirement that I just mentioned earlier is you must provide the parties with a timely opportunity to seek modification or reversal of the recipient's decision to provide, deny, modify, or terminate your supportive measures. So again, like I said, maybe you offer something that is slightly different than what the party asks for. Maybe the one party asks for a supportive measure that doesn't seem like it's going to overtly burden the other party on its face, and after it's been implemented, the other party comes to your office and says, hey, this is actually really affecting my access to whatever program or activity they're both involved in. There must be an opportunity for the parties to seek modification or a reversal of maybe a reason to not give a supportive or decision to not give a supportive measure. That review must be done by an appropriate and impartial employee, and it can't be the person that made that initial decision. So if your Title IX coordinator is the one who is doing supportive measure decisions and they decide to not implement a supportive measure, and that party asks for review of that decision to not implement, you must have another impartial employee who has the authority to reverse the decision of the Title IX coordinator do that review. It doesn't have to be someone that appears in your org chart as higher than your Title IX coordinator, but they must be empowered with the actual authority to reverse those decisions if they were to choose to do so or find that that's appropriate. And you must offer the opportunity for this review if the circumstances change materially. Maybe it's a new school year and there's new classes, new buildings. Maybe there has been another event that's occurred. There's going to be different things regarding every single allegation, but just think about this materially word and determine whether there's been a real change that adjusts what is necessary. You can also choose to offer this at any time. So you can choose to always allow for the modification of supportive measures and review of supportive measures if you want. It's just the baseline is that you must offer if the if there's a material change in the circumstances. Okay, so Ashling is going to talk a little bit more about pregnancy. I know we've been touching on it throughout this presentation, as the regs do throughout them as well, but we've got a little bit more for you.
Yeah, this is a key addition to the new regs. And a lot of you at universities, may be thinking, well, this just kind of makes sense, right? But maybe these policies only applied to employees before. Now they're applying to students. So we see the definition, there. You can't adopt any policy, practice, or procedure, that's based that would take away from the pregnancy or related conditions. Let's think about voluntary leave of absences that's specifically addressed in the new regs, lactation time and space. You can't ask someone pre-employment, if they're a Mrs. or a Miss. These are just the very highlights of pregnancy, but we certainly wanted to address them as well. Most notably, what's not included, and this is something, the NPRM for athletics has been tabled. So that's not something that was dealt with in these new regs. So, you should definitely be aware of that. So, how do we implement these? We've gone over a lot. What should you be doing now? So you have to read the regs at the very least, you've got to read the regs. So there's an unofficial version of the regs, and it's a little bit easier to get through if you ask me. Things are double spaced. You can read it a little bit easier. It's 55 pages, and the first 10 are definitions. So it's not a big read. I know if you've seen people posting online, you've seen like these huge binders, that we all have on our desks that are color coded and tabbed. But for most people, you have to read through the regs themselves, whether you read through the 1,500 plus page of the preamble in the unofficial regs, that's up to you. I will say the preamble is nice because if you have a particular section that you have more, further questions about, you can go and read just the preamble and the discussion about, that particular section of the regs. So, number one is I really do encourage you to read those regs. The official version, I just want to mention, is like a 3-column, very small print document. So it may be harder to read and highlight and note. But we're going to provide that to you as well, along with the slides and the recording of our presentation. So right now, it's really the time to meet with your Title IX team. Meet with the powers that be, decide what works for your college or university. What's working now with your grievance process? What do you want to change? Do you love the live hearing and cross-examination? If so, keep it in effect. I mean, there's less things you have to change. Do you want to go back to single investigator model? That's fine too. Do you want to do both? Do you want to do one for sex discrimination and the live hearing for sex-based harassment? Again, talk through what works for your school. That's the beauty of these new regs, is that they do offer you the flexibility to be able to decide what works best at your school. And you get to be the ones to implement that. So once you decide, what works, what do you want your grievance procedures to look like? You should be identifying, potential new members of your team, strategic alliances on campus that can help you, can work with you. At Title IX coordinators, who are you going to get to, help you wear all these different hats? You have to oversee them. You don't have to actually do all of this new work. What does prevention look like on your campus? Training, you have to be talking about who needs to be trained, when and how, and ensure that your Title IX staff is trained before the deadline of 8/1. So once you're huddling with your team, you're meeting with your team, you're deciding what's best, then you need to reduce these ideas to writing. So you need to revise your policies and procedures. So you need to talk about who's doing that. When are they doing it by? What's the deadline to get that to the stakeholders for a review and approval before this can be published on 8 and effective on 8/1. So again, these are all of the things that you need to be talking about. Who's going to revise the forms and the training materials? You have to draft a non-discrimination statement. You have to, issue a notice to your community. This is important. Acknowledge that there are new regs. That there's an effective date of 8/1. You ensure your community that you are going to be in compliance by 8/1. And also assure them that the current policy is still in effect. And that's true. Don't go throwing out your old regs yet. These are still in effect, and this is what you're going to be dealing with, until that 8/1 effective date, and possibly even after, right? If you get complaints for conduct that occurred before then. So these are all of the things, that you should be doing as a team. I'm sorry that we didn't get to answer many questions throughout. We tried to incorporate some of them in our answers. But we will, over the next weeks and months, we thought we may have more informal meetings, just to have a kind of a coffee talk with different topics for the Title IX regs, and we'll certainly ask you to join us for that. But until then, thank you so much for joining us here today, and let's all take a breath and move forward towards that 8/1 deadline. Thanks again.
And as a reminder, we will be sending out this presentation, as well as I saw someone ask for that 50-page informal regulation document. We're sending that out as well. Ashling, is there anything else we're putting in that email?
Yeah, we'll have the unofficial regs, the official regs, the slides, and then the link to the recorded webinar. All
Wonderful.
right, everyone will get that, and you can share it with your team as well.
Great.
All right, thanks again, everyone.
Thanks, everyone.
Bye-bye.